After,
Where is the event being held?
at the church,
Okay.
our men are putting on a special event for the ladies, and they're feeding us. They're doing the
Oh,
catering, everything.
right. That's
So
excellent. Yeah.
I'm going to enjoy that.
Brilliant.
Okay.
Yeah. At least it's bright today. The sun is out. Can see blue sky, but it's still a bit cold. Just waiting for a few more people to join the call. I think all the ladies gone to the Sunday event, Mother's Day. Everybody's gone to Mother's Day today. So Ivy, while you're listening, is there anything specific that you wanted to find out today? We're just waiting for a few more people to join the call. So while we wait, just check the website for our information, justiceforwindrushgenerations.co.uk.
While we're waiting, can I ask a question?
Sure, that was what I said to you, if there's anything specific that you wanted any help with. So please do.
It's a general question regarding the Windrush folks, especially those who are not allowed back into the country.
Okay.
If I just use Jamaican example, you know
Yeah.
that you have to pay for your medical bill and all of that.
Yeah.
What if during the time they're out of the country, they have medical issue, which they would eventually be treated by the NHS if they were in England?
Yeah.
Can they put that in as part of their claim?
Yes, of course. So basically, anyone that is eligible for the Windrush compensation scheme, and when we say eligible, it means you would have to arrive and live in the UK by a particular date. So from a Commonwealth country, you would arrive and settled by 1st of January 1973. You could have lived there for a number of years and then went out to any country of the Commonwealth. And then because of the 2-year rule that was part of the 1973 Immigration Act. If you exceeded 2 year, you were no longer eligible. Your stay was lapsed. In other words, those people whose stay has been lapsed, they're still outside the UK. But if they qualify being eligible, then they can return to the UK, and part of their claim will include a number of different elements. So the first thing that we would suggest for people is to, if they're outside the UK, there are ways to get back to the UK, and then you can deal with your claim once you're back in the UK. You can also make an application from outside the UK. So it doesn't matter where you are in the world. Once you're eligible, you can make an application. And when you make that application, there are a number of elements to your claim. So, for example, you just mentioned health paying for health, etc. Um, Issues around housing, homelessness. There's a whole 12 or 13 different um, uh, heads of claim. And also, if the person has been removed from the UK, whether that would be deportation or if the person been held up in detention, all those elements become part of the claim.
Okay,
Does
thank you.
that help to answer your question?
Yes, it does.
Yeah,
Because on the this is not directly Windrush, but it
yeah,
is related. I mean, I came here at the age of 12, gone through everything now that I'm a pensioner.
yeah,
And I'm thinking if I were to be visiting Jamaica, although you have travel insurance and health insurance, but on a broader scale, I should still be covered. I want to say we should be putting in that we who is entitled, instead of being branded as
yeah.
coming back to England as
So
medical tourists.
can I ask two questions for clarification? So you came to the UK at the age of 12, did you say?
Yeah.
Yeah, and your parents were already in the UK?
Yes, I haven't got a problem with citizenship
Okay,
or anything like that.
right, okay.
And we have, and because
So if
we
yeah,
we have a question, what about the claim or the compensation for people who suffered genuine and blatant racism? And
no.
they said that's
The
not
answer,
included.
the answer to that, that racism is not part of the claim.
I
Racism is
mean,
a general thing. So your
yes.
claim would have to be directly impacted as a result of your status. So if there was no issue with your status, because you've got your passport, and so if there was no issue there, there is no compensation claim to be had. So
Yes.
the Windrush scheme, and this is very important, the Windrush scheme, firstly, the person would, it's in two parts. So you have status rectification, that is to get your documents. That's the first part. However, if an individual was impacted, suffer loss because they did not have the document when they were asked to produce the document to show evidence of their right to be in the UK. If they had suffered any losses, there would be a compensation claim. The opposite would be if they did not suffer any losses, there is no compensation claim.
This, I I'm sort of laboring the point. You see, I'm thinking, I know I suffered loss by the prejudice against getting the education system to put me through to the point, and other members of the family, where we would have been in a higher position to get jobs and our status. And we will never get any compensation, but we were still affected as Windrush children or descendant. And one of the claims that I am concerned about is I now have free time, want to visit Jamaica, the Caribbean, but I think we should have our medical. And that's one of the things the Commonwealth, as an interim to reparation, should be saying when British
Yeah, that yeah,
folks come out,
there's
they
two
should
different
be getting.
things there. So you're referring to two different issues. So um the
I'm only
reparation,
I'm only raising these questions as general question because
yeah,
there are issues that we are affected by.
yeah. So let me try and answer your question a little bit. So reparation is a separate issue. And reparation, we don't really talk about reparation because it's not within the Windrush compensation scheme. Now, there are other organizations that is part of the bigger global reparation that CARICOM and others are pushing through. The the compensation scheme came about as a result of immigration issue. So I go back to the point, if you did not suffer any losses, there is no claim. Now, let me give a scenario. If you're working in the NHS in 1969 or 1960 or 1970, and you were asked to bring your documentation in after working for 10, 15, 20 years, because in 2012, they introduced guidance to employers. They should do immigration check to make sure people employed have the right to live and work in the UK. So those employees who were there for a number of years, they were asked to bring documentation into their employer. Now, if you did not have any documentation to evidence that you have the right to live and work in the UK, you were dismissed from your employer. And if you were dismissed from your employer, that will trigger that you were affected. And if you try to get another job, you could not get another job. If you try to get any public services such as benefit, etc., what we call access to the public resource, everywhere you would have gone, you would be asked to produce evidence of your documentation. And because you did not have that, you would have continued to suffer losses. Yeah. Now, all those losses is part of a compensation scheme that the individual can claim. Yeah? But if there was no loss, there is no compensation claim. Does that make it a little easier to understand, Ivy?
Yes, I do understand. Thanks for
Okay.
explaining all of that, because I'm wanting to hear on behalf of
But
people.
also, other members of your family may have experienced, issues. So even if you directly hadn't experienced anything, other members of your family may have experienced issues relating to status. They may not have had the documentation when they were asked to produce it. So they may have experienced losses. And this is why it's good to have conversation with family and friends and relatives,
Well,
etc.
if I can say, all the families that are in England right now, it's not, fortunately for me, I did work with the Home Office from 1975, and I only left after 5 years because I realized I was not going to be a British civil servant for
Yeah,
life.
yeah.
So, and I was
So
going
you
to
left
be.
on your own accord.
No, yeah. That was no problem. I had a good service. I could go back anytime, no problem with
Yeah,
contact. So I did manage to sort out my family and everything. All our paperworks were
yeah,
done because my mother, the children been out of the country, but they came back, and
yeah,
so they never broke the rules, so to speak. So I'm asking in general because many people who and basically tried to encourage to do the right thing who didn't.
yeah,
So you see them now in the problem of being able to come back, problem, all sort of problem.
yeah,
So I'm asking it, but as I said, now that I am a pensioner
yeah.
and I don't necessarily want to be in England through the winters and all of that.
Yeah, you can go and come
And
as
just,
you're free.
and I
Yeah.
just say, it's not your group that is dealing with my particular issue,
Mm.
but I just want to know that, we are all Windrush, and we all, just because we have the status doesn't mean that we're not suffering, but I know you're only dealing with the status
Yeah,
issue.
yeah.
So that is not
Yeah, and
my
and
area,
it's good to know, because one of the things that we always mention, there are those people who are trying to get back to the UK, or as you started the conversation, are locked out of the UK because of the
Mm.
2-year rule. Those individuals can still return to the UK, and we're encouraging people to make application to return to the UK. Now, whichever Commonwealth country the individual is living in, they probably don't know this, but if they do want to return to the UK, they can, and they can apply for what is called a return resident visa. A return resident visa apply for the individual while they're outside the UK to return to the UK. On returning to the UK, those individuals will be able to have what they call multiple entry, up to 10 years, to go backward and forward, to whichever country they're from, without any issue. But the first step for the individual outside the UK is to make an application for returning resident visa.
Okay, thank you for that.
And we're encouraging a lot of people to actually make that, tell their friends and family, because not many people are aware of the returning resident visa, how to get back to the UK.
And that's if you're out continuously for over 2 years.
Yes, if you're outside the UK, it would have meant that your visa would have lapsed. The 2 years would have expired. So you could have been out for 2 years and 6 months. You would not be able to enter through the normal route because your status would have lapsed. And those individuals whose status has lapsed, they can return to the UK if they so wish by applying for returning resident visa. And the application will give them 10 years multiple entry visa to come and go as they wish, to spend up to 6 months at a time, up to a 10-year period.
And on that type of visa, would they have all the rights, the free healthcare, doctors, and all those?
Well, if they're making a claim under the Windrush compensation scheme, that will become part of their claim.
No. I mean, if you come back,
Yeah,
after after 3 years,
yeah,
you return to the UK. While you're here, you
yeah.
need to go to a hospital for surgery. Would you have to pay?
You wouldn't
Or
have to
would you,
pay. No, because
okay,
you would have been eligible, as a,
as a resident?
yes. So you wouldn't have to pay. That is my understanding. And
Okay.
the people have returned. We have assisted individuals who have returned to the UK, and they've been able to access NHS services, etc.
Okay, thank you.
So
That's
please push that message out there that if you're locked out of the UK, there is still a route for you to get back if the person wished to come back to the UK. Now, before that individual return to the UK, a part of the test would be, have they got any links with the UK? Do they have family living in the UK? Do they have property in the UK? Do they have a business in the UK? They have to demonstrate there's a connection to the UK.
okay.
And if they cannot demonstrate that, the application will not be successful.
Right. So in a way, he's the same as born in Jamaica. I try to maintain over the year that I have both passports,
Mhm.
and my Jamaican passport and my British passport.
Yeah.
So I preserve my dual nationality.
Yeah, because having the British passport gives you the right, as a British citizen, to public services, etc.
Okay.
Yeah.
All right.
But
Thank
as
you.
far as insurance, the only point I like to make, when an individual travel out of the UK to any country, they would need to organize their own travel insurance.
I think they said 7.
Okay.
I'm rushing to come
Yeah.
back.
All right. I'm sorry. Sorry. I'm just arriving at my destination.
Yeah,
Okay.
that's fine.
Thank you.
You're welcome.
I've taken up enough time.
That's all right. Mhm. Is there any further question? We're just waiting for a few people to log on, but if there's any specific question, please, we can deal with that straight away. Any question around eligibility? Any question about any particular part of the claim? We can deal with that while we're waiting. So the Windrush compensation scheme was set up in 2019 as a result of the scandal that broke in 2018. So since April 2019, the compensation scheme been in progress. And the compensation scheme is in two parts. Firstly, we always encourage people to do the test. The first test is check your status to see whether you need to rectify your documents. And for some people who came here as a child, they may need to rectify their status because they would have traveled either on a family passport as a child, and at later years as an adult, they may want to apply for their own passport. So we always say to people, the compensation scheme is two parts: status first. And when we say status first, if an individual had problem getting their status, and that problem could be that they're not eligible under the scheme, or they fall out of the Windrush scheme. But if they arrive in the UK, both themselves, their parents, or their grandparents before the 1st of January 1973, they would be eligible for the scheme. That would be status scheme. If they've been impacted, they suffer any loss because they were asked to produce evidence and proof that they have the right to live and work in the UK, and they could not do that because they did not have any passport or any documentation, i.e. they came here on their parents' passport as a child. Then once they're eligible for this scheme, they can make an application. And we always say eligible because there is eligibility set out by the Home Office, and that is in the Windrush Compensation Scheme guidance. And Commonwealth country residents would need to arrive in the UK by 1st of January 1973. From any other part of the world, you would need to arrive and settle by December, the 1st of January 89. Sometime you will see in print December 88. So if the individual are able to show that they were here and settle, then they're eligible for the scheme. If they arrive in the UK after the date of eligibility, after 89, let's say they arrive in the UK in 2001, they're not eligible for the scheme because the scheme have a set date. The timeline for Windrush is 1948 to 1989. That's the timeline. After that, your query may well be an immigration query, not fall within the Windrush scheme. So it's always good to know the dates. Dates are very important, either for yourself, your parents, or your grandparents. Dates are very important. Roland?
Yeah, good afternoon. Can we have a discussion or can we clarify what is meant when we say if they have suffered losses? There are a couple of points, or at
Yeah.
least two, I need to address.
Yeah.
Suffer losses as well as resolving a status first.
Yeah.
But first, let's deal with suffering losses.
Yeah.
What is meant by suffering losses?
Yeah. Good. It's a good point. So the Home Office used these terms in the guidance, and there's two words that is used interchangeable. So sometime you will see, have you been impacted? Yeah. So that word impacted and suffer loss, they're used interchangeable. Yeah. And let's try and break it down. So an individual who have lived in the UK, they were settled in the UK because they arrive at a particular date within the scheme. Let's just use 1st of January 73 as an example. They arrive and settled within the scheme, and maybe they arrive as a child and did not have a passport. When they decide to have a passport, to apply for a passport, there are a couple of issues that we need to bear in mind, because it's not an automatic right to a passport. The guidance says if you, the person, your parent or your grandparent arrive from a Commonwealth country before a particular date and settle, yeah, and that particular date runs from 1948 up to 1973 for Commonwealth countries. 1948 up to 1989 for any other part of the world. Arrive and settle. The guidance also make the distinction between status application, rectifying your status because you did not have the documentation and you need to get it. Rectifying your status is the first step an individual will do. Forget about compensation. That's the first thing, is to rectify your status, to get your documentation right, to get your passport, to say, now I've got my document. And when I'm asked for my document, I can show evidence I've got my document. Now, if you were working for an employer in the 60s, in the 70s, in the 80s, and suddenly, after working for 20, 25 years or beyond, the employer would say to Mr. Smith, can you bring your passport in tomorrow? And the reason why the employer will ask Mr. Smith to bring his passport in, because in 2012, the government introduced a new check on individual right to be in the UK and for them to have the right to work. So the employer became immigration officers checking employees' status. And any individual that could not produce their ID, their passport, when they were asked to produce it, the employer would dismiss that individual. That individual could not get a job anywhere else, because wherever that individual go, it will be the same issue. That individual could not apply for social security benefit because it's part of public fund. That individual could not be treated by the NHS, part of public fund. That individual could not get any property to rent because it's local authority, it is public fund. So then that individual has now lost their job. Consequently, they would lose their their place of living, whether that would be rented or whether that would be mortgaged. They would lose that. So now when it comes to have you suffered losses, the answer to that individual, yes, they have suffered loss. Because when they were asked to produce document, they did not have it. So they've suffered loss. That individual will then have to make a claim under the Windrush compensation scheme. And in making a claim, that individual will have to highlight and list all the different areas that they have suffered loss, or been impacted. And the Home Office guidance give a whole list of things that the individual would be denied. They could not access that. Opening a bank account, or if they had a bank account, the bank account was closed. They could not rent. They could not get a driving license. There's a whole list of things. They could not get any further employment. There's a whole list of things listed in the guidance as to what losses are. Did you suffer loss? Were you impacted? And clearly that individual has been impacted, has suffered loss. Now, every claim will be different. Some people will suffer more losses than other people. Yeah? But losses will have to be evidence. So you lost your job and you could not get any further work, right? Because you come up with the same situation. So that's an employment issue. Yeah. So when you look at the guidance, so employment, job loss, that's one claim. Housing, yeah, that's another area. Okay? If the individual suffer as a result of being detained coming in or out of the UK, that is also part of a claim. If the individual was detained for more than 30 minutes at airport point of entering, as they do with many Black people, they would stop you. They will ask you question as to where you've been. They ask you question about your personal life. They ask question about your family. And you could be held up for 30, 40, 50 minutes and then let through baggage and get through immigration. So we always remind people in their claim that is known as detention. Some people, unfortunately, has been locked up in detention center for a fixed period of time. Again, that has become part of your claim. Some people would have not been able to apply to go to university, or their children, or a driving license. All these are listed in what the Home Office calls suffer losses. But it's not an exhaustive list. It gives an example of the different claim that the individual can claim against. Okay? But having said all of that, you're asked on the application to evidence these things. So you then have to put your losses on the application as to when it happened, and you have to answer all those questions on the application relating to suffer losses or been impacted. Those are the two words, the only two words the Home Office use: suffer losses or have you been impacted. Does that help, Roland?
My view is that suffering loss and impacted are two separate things. And I believe that's the approach we need to take, because if we are saying suffering loss, you can be impacted and have not suffered financial loss.
Mhm.
Because, and if
I
we do,
agree with you.
if it's not presented that clearly,
Yeah.
a number of claimants are going to be confused.
Yeah.
You don't need to have suffered financial loss
Yeah.
in order to have been impacted.
That's a very
So
good
you
point.
are
Let me just
you-
stick with that. Let's just stick with that, because that's a very good point, because impact also on the individual, the impact on the individual, their health, the trauma.
no, I don't mean it like that.
Hmm?
For the mere fact you were declined the documentation.
Mhm.
So let's say you made the application for the documentation, and within a week you get the documentation. Now, with a short period of time,
Mhm.
you get the documentation. You suffered no financial loss.
Mhm.
However, your life was impacted and it was disrupted.
Yeah.
Hence, on that basis, you'd be entitled to an award.
Yeah. Yeah. I mean,
So it needs, because if we don't take that approach, an assumption will be made that you have not suffered any loss.
yeah. Yeah. I mean, the thing is,
Therefore, you would not be, you would,
I'm
hold
reading
on, you'll not be,
directly. I'm reading
hold
directly.
on, hold on. I understand that you're reading directly from there, but it needs to be made clear.
Mhm.
It's impacted, if your life was impacted or disrupted.
Yeah.
It could have been impacted and you've not suffered financial loss. It's only impacted, and that's under the impact of life heading. So it's only that heading
Yeah.
that you would be entitled to compensation.
Mhm.
Because a number of individuals are assuming if you've not suffered financial loss, then you're not entitled to an award. And in a number of cases, there has been cases where the caseworkers have made a nil award because
Yeah.
they said you have not suffered any losses, and
Yeah.
that would have been an incorrect outcome.
Yeah. It's a good point. It's a
Go
very
ahead,
good
please. Go
point.
ahead, please.
Yeah. It's a very good point. And we will continue to seek clarification on this directly with the Home Office team, because the guidance is only a guide. We can't take every word that is written as mandatory. The guidance is there to help us to understand the scheme and what particular area of the scheme that may apply to us. But the most important thing is the application, how what we put down on the application when asked those questions. Yeah, there are specific questions that are asked on the application, and we have to answer those questions. And the guidance is the place we look to see what is expected, what's the expected answer for that particular question. And it is true that many applicants do not give enough information on the application for the caseworkers to make a decision. It may be that they needed to give more information. Instead of having one paragraph, maybe they need to give 2, 3 paragraphs to explain more about what impact they've had. And the guidance is there to sort of tell you the areas that you need to think about in terms of, for you to think, well, yes, that's me, or that's not me, or that didn't happen. Roland?
I think in most cases, it's the quality of the information rather than the quantity where a lot of claimants fail.
Mm-hmm.
I think the reason why they fail in many cases, I mean, not put in the relevant information, and why they may have a nil award when they should have been awarded, is because they do not understand exactly what needs to be put into the statement, so to speak, or whatever information they put in forward. So you need to be clear and concise and get to the point as quickly as possible. Nothing wrong with it being short and to the point, short, clear, and concise and to the point. Because if you go on elaborating when elaboration is not warranted or not necessary, you cause confusion in many cases. Because the caseworker, the reader, just need to have a clear understanding, get a clear understanding or reflection of exactly what was done to you or what happened to you as quickly as possible. So it's not the amount, it's not the quantity, it's the quality that is important.
And also,
hence the guidance need to be clear.
We also say to people, that is why it's good to get some help, because an advocate will help you to formulate that response better than you trying to think, well, what shall I say here? I mean, we always encourage people to get somebody else to, to have a look at their application, to look over it, and even better, to contact an advocate who have the experience to be able to make sure that you are claiming all that you're entitled to. In other words, the impact is measured and is very clear what you're claiming for. It's not general, it's very specific. Every application will be different because people will suffer losses in different way and over over a longer period or a shorter period. But most importantly, it is the information that put on the application form that the caseworker will be reading. When the caseworker receive your application, they will only go by what is put on the application. And if the information is not clear to the caseworker, they would probably will offer a nil award. And we've talked to many people who have done the application themselves, and they said they didn't know what they were doing when they sent the application in. They just put it in, and they, if they had somebody to assist them, they would have put in a better application. It is not an easy read for people just to read the guidance, answer the question, and send your application in. Okay? For some people, they have difficulty in doing that. For other people, they may able to do it without any issue. But we know that there has been a number of nil award being made. We don't know the exact reason for it. And that need to be established as to why there's so many nil award. Is it coming from the applicant, or is it coming from the caseworkers? Roland? Roland? Hello, Augustine. Nice to see you. Hope Canada is okay.
Gary, can I come in there, Gary? In a lot of cases,
go on.
A lot of cases it's coming from the caseworker.
Yeah.
As of recent, because when the scheme was launched, as you know, many people, including myself, even some that of advocates, lawyers, etc., were not clear as to what should be included in the statement of fact.
Yeah.
And the various heads of claim from impact on life, etc. But recently, I have come to understand that quite a number of the caseworkers, the decision workers themselves do not seem to be clear do not understand the guidance note themselves in some cases. And in some cases, I believe that they deliberately are making nil award or undercompensating, so to speak, not awarding at the level that they should award at.
Yeah.
But a lot of the statements that are information that's being submitted by the claimants, in many cases, is irrelevant and is not covered by the scheme.
Yes.
They're not clear as to what information needs to be put in or should be submitted.
Yeah.
The quicker you can get to the point, I believe, is best for yourself and the reader, the
Yes.
caseworker. No point going all over the place. It's not an opportunity for you to rant or for you to rumble. Get to the point, be clear and concise as possible.
Yeah.
And the next question I'd like to address, I had a few questions actually, is, and before I get to that, the guidance note.
Yeah.
The assumption is made when it comes to, as you know, we've got three categories. We've got primary, deceased, and close family member.
Yeah.
No difference between the primary and the deceased, except that that individual that would have been eligible and entitled as a primary claimant is now deceased, hence the executor of the estate, of the deceased estate, or the next of kin will submit that claim proxy, so to speak. When it comes to close family member claim, the assumption is made in other cases that the individual would have had to come from a Commonwealth country or have that Commonwealth connection. That is the case in most parts for the primary claim and the deceased estate claim. However, in terms of a close family member claim, you do not need to have come from a Commonwealth country or have a Commonwealth connection. You could have come from any part of the world and don't even have had to enter the UK before 1989 and all that.
Yeah.
And the specific close family members we'll be talking about here who do not need to have that Commonwealth country. And those are wife or husband of the primary claimant. Don't need to have that Commonwealth connection. Also, cohabitees who have lived with that individual for 2 years or more. Don't need to have that Commonwealth connection. Stepchildren and step-parent do not need to have that Commonwealth connection. Could have come from China, Japan, or any other country that is not a British Commonwealth country, and still would be eligible and entitled to apply as a close family member and awarded compensation. They came from China when they're 19 or 2000 or whenever. Get married to someone who was born in the UK, and that individual that you married to, parent or grandparent came from a Commonwealth country. That individual would be eligible as a primary claimant. You came from Japan, China, or anywhere else, married to that individual had issue in 2015 that impacting them made them eligible and entitled, the primary claimant eligible and entitled, and you, the close family member who came from China, the wife or husband, stepchildren or step-parent or a cohabitee, you would be eligible and entitled to compensation. So that needs to be made clear because the assumption is made in many cases when it comes to close family members that you need to have a Commonwealth connection. That's not the case.
Yeah.
And move on to the next question I would like to address, which is you having to resolve your status first, especially for those outside the UK, that you need to resolve the status, i.e., you have to apply for a returning resident visa and return to the UK prior to you submitting your application for compensation. This has been the case somewhat, but I've had discussion with the community engagement team openly. This question was raised. And they're saying they have had a number of claims that were submitted without the claimant having to return to the UK. Primary claimant in this case that could have been locked out of the UK In many cases, these individuals do not necessarily want to return to the UK. They could be 85, 90 years old, got no interest to return to the UK, but they can establish definitively that they were impacted and their status would have been resolved or the status was impacted due to no fault of their own. I'm not talking about the 2-year-old.
Yeah.
No, that's let's take that out of the equation for the time.
Mm-hmm.
Okay. Okay, we got cases. I've got one particular case where the individuals are right to board, had the right to travel in and out of the UK, not indefinitely to remain, right to board. However, that individual was denied re-entry to the UK and was out of the UK for a while. In that particular case, that individual will not need to return to the UK. And there will be other instances where the individual will not need to return to the UK because there are the issues out there outside when they lost the right to return to the UK due to the 2-year rule.
Yeah.
Okay? So that we need to be clear on that as well.
Yeah.
Do
If you
not
recall,
necessarily need to return. Hold on. Do not necessarily need to return to the UK before you submit your claim. You can make a claim from outside the UK.
Yes, that's correct, because we did put that directly to the Home Office, and the response. Although we haven't seen any amendments to an update, but they did tell us, online, that the person do not need to return to the UK to make a claim. And as you said, they may not wish to return to the UK. They can still make their claim from whichever country they are residing. We did ask that question directly several times to the Home Office team, and they said yes. Yeah. So what we haven't done, we need to test that out. How many people are actually picking up that opportunity and say, yes, I want to put my claim in. I don't want to return to the UK, but I want to put my claim in. We need to get those claim in because the Home Office assured us that they can make a claim from outside the UK, and they do not wish to return to the UK would not affect their claim. But we now need to evidence that. So, do you know of anyone who has actually submitted a claim from outside the UK since we've had that conversation with the Home Office team?
I've got a number of those cases.
Because we need to track this now to make sure, and if those individuals are experiencing any difficulty, we will pick that up with the Home Office because they assured us that it's correct. You will not be disadvantaged if you make a claim outside the UK and you do not want to return. They assured us that is the case. We now need to put it to the test and gather the evidence. So if there are individuals who are now making the application and they're having problem, we need to pick that up with the Home Office. Because I haven't seen the update in any of the updates to confirm what they told us online twice and in person another couple of times. I've not seen any changes to the guidance that will include that, yet we were told that they will not be disadvantaged. They should go ahead and make their claim.
Well, I put in a claim 2 years ago, and they said, yeah, you're eligible. But then after I put it in, they said, Neil award.
They give you a nil award. What were you claiming for?
Let's see, loss of property, loss of clothing, my records, loss of job opportunity, pension, that sort of thing.
Did you submit that claim, Augustine, by yourself, or was that claim submitted through a third-party organization or a solicitor or a lawyer?
By myself.
By yourself. Okay.
Yeah.
And
Uh,
did you challenge the decision?
I just challenged. I got a lawyer, and we put in a different application.
Yeah. And
However,
since you've done that, what's the outcome? What's the update?
I'm still waiting.
When was it submitted? Resubmitted?
This year.
This year. Okay. All right. So
Early.
we're now in March. So, you know, we're just coming into end of March. So it's 3 months. Again, it's good to know this because these are when the new commissioner is appointed, there are several issues that we want to raise directly. It's good now to gather some evidence, something that we can approach the commissioner directly over this. So 3 months is probably you know, normal to wait. So I don't know how long. At one point, we were asking the question about how long the Home Office take to process application from the time your application is received and acknowledged. We were told 4 to 6 weeks for acknowledgement, and then dealing with the claim itself. There was no fixed time as to when that would be, whether 6 months, 12 months, etc. There was no fixed time. I think, you know, this is an area that we need to monitor as to how long claims are actually taking to be processed. We haven't got that information yet as to the average time. Now, the new Home Secretary has injected some additional resources into Windrush, and I don't know whether that is to increase the number of staffing for Windrush. I still don't know how many people actually in terms of caseworkers exist. I don't know how many people they are, and whether that team need to increase. And the next question that we've raised directly with Home Secretary is about the cultural understanding of the caseworkers. That's an issue that I think is long-standing. We don't know these people that are making decision on these applications. We don't know much about them as to, you know, their experience, etc. So these are some of the things that I think, you know, when the commissioner is in post, that we can bring directly to the commissioner. Probably summer, late summer.
Can I comment on a
We're told, Augustine, that the commissioner should be in post by summer. So if we then allow a couple of months for the commissioner to you know, establish themselves, I would think, you know, August, September, we should be, you know, pushing some of these issues directly to get answers.
Can I just comment there, Gary?
Go ahead, Roland.
And it's in relation to Augustine's case and what Augustine just said. In November last year, there was an update to the guidance and to the scheme. Do we know what that update or what that change to the scheme is?
Yes, there was a we have discussed the update that came out in November 2024.
Yeah, do we know what the change is or what the update is?
I couldn't tell you without checking, but
right. So it's no point checking. In the guidance note, it just said there's an update, isn't it? It does not specify what the change is. I've got some kind of indication about that.
No, it did tell us,
Openly.
but there's like Annex 2. It did tell us what the changes were.
I've checked, it does not say specifically what the changes. Did not, there's no specifics there.
Okay.
There's some indication, somewhat, not specific there, that those that were locked out, and I think the judicial review that came out, that we had some result, and a verdict on a few weeks ago, indicates somewhat that those that were outside the UK for more than 2 years, and their indefinite leave to remain lapsed. In some cases, they would be entitled to compensation going forward for the mere fact that they lost their indefinite leave to remain. Not in all cases. But we need to get specifics, and we need to get clarification on that. We need to know exactly what those changes are. Now coming to Egbert. In Egbert's, Senator Egbert, Augustine. Now I go into the specifics of your case, Augustine, but making a general point. In the case where an individual who have lost their indefinite leave to remain had the right to return, and they approached the British authorities abroad, whether it be in a high commission, consulate, etc., and they were given misleading information, and as a result of that misleading information that was given to them, caused them either to make the wrong application or to stay outside, the exile outside the UK prolonged. In a situation, and that I would need to raise this with the High Commission, in situations like those, that individual should be compensated, or if they should have been given, because those who have the strong and continuous ties to the UK, in Augustine's case, and approach the High Commission, they should have been given clear and concise information that they can apply for returning resident visa, or whatever approach they need to take, and continue living as they were living before. If they did not have those specifics, or were given misleading information by the High Commission, like what happened to in my parents' case, then those individuals should be awarded. And that's a point that we need to push on that.
Yeah.
With the Windrush Commission. Go ahead, Augustine. I think you're going to say something, Augustine.
Sorry?
Yeah, go ahead. You're going to respond to what Roland just said.
What I just said.
Yeah. The thing is of getting returning residents, they don't want you to get any award. They blame the individual for being out of the country for more than 2 years, even though we weren't aware of indefinite leave to remain. And it's a new tactic that they had, not letting us know what happened when individuals went abroad. This is why they gave me a nil award. They won't tell you that in the letter either, because it will show that they were guilty in the way they did things.
Just pause for a moment, Augustine. While you were talking, I found the updates to the 1st of November 24. Let me just read you something. What the changes were. So changes from the last version of the guidance. Intention, background, operation of the Windrush scheme, deciding the Windrush compensation application, Windrush scheme groups, returning resident guidance, and the table of Windrush scheme groups. So let me just click on this one about returning residents. So this is the latest information updated. I'm going to read.
Gary, just hold on, please. Is that for status or is that for compensation?
Well, let me just read it. You'll pick up now as I go through.
No, Gary, there are two separate guidance. One for status There's a casework guidance for status,
This
and
this
there's
is the
one
full
for compensation.
guidance for caseworkers. Yeah, 8.0. This is the full guidance for caseworkers.
Go ahead.
Yeah. Returning resident guidance. This section set out guidance on how you should consider returning resident application. This is telling the caseworker what they should be doing. Yeah. This section set out guidance on how you should consider returning resident application specifically made under the Windrush scheme. Part 1, Section 2 of the Immigration Act 1971, which came into force on the 1st of January 1973, states that a foreign national who ordinary resident in the UK on the date are deemed to have settled status, indefinite leave to enter, ILE, or indefinite leave to remain, ILR, unless they are either, 1, exempt from the immigration control on the date, 2, had the right of abode. Let me just pause there. Yeah, notice the point. If they were exempt from the immigration control on the date or had the right of abode. Those are the two exemptions that applies to returning resident.
So we there's no clarity as to what the update is because there's no comparison. They did not say it has not said, it does not say what it was before the 1st of January, what the 1st of November 24, what the situation was pre-1st November 2024.
You would have to go to the version 7 because this is version 8. This is the updated version.
I've been to version, and I've been to version 7.
Yeah.
And there's no clear contiguous argument there that the reader can understand clearly what it was pre-1st of December 2024 and what the situation is now post 1st of November 2024, that you can make a comparison and understand the implication of the change. That is not there.
Okay. All right.
And that needs to be there in order that those making the application can understand clearly when they get a result, a final award, a decision.
Okay. Hold on to that point for a moment, Ro. Let me
What's
just
the situation is. There
read
needs
the
to be
next paragraph.
clarity there. You go ahead, please.
Let me just read the next paragraph. Where a person is subject of a deportation order made on criminal or non-conducive ground, they should be advised to apply to the criminal casework immigration enforcement for their deportation order to be revoked. Applicants should be directed to apply to the criminal casework at the following email address. So now, previously, I have not noticed that in the previous version, but now they're saying if there was a deportation or order was made non-conducive ground, they would be advised to apply to the criminal casework immigration enforcement in order to get it revoked. I have not read that in the previous version 7 before.
Okay, so let's discuss that. What's the implication of that?
Well, I guess
what's your understanding of the implication? What will be the implication of that change?
Well, for those people who were wrongly deported, they have a grounds.
Well,
what would the class as wrongly deported?
Well, wrongly deported, if they were not deported for criminal activity, right? Then it would have been a wrong deportation based on the then immigration rule.
And that is what the applicant would have to go up against.
Yeah.
Because there's no clarity. That's all that could have been referenced and clarified in simple, basic, straightforward English. There's no clarity on that.
There is
for most applicants, that will be just gibberish, it will be just rambling.
Yeah. But then, as I said, the guidance doesn't give you everything.
No,
there's
I
always
understand
going
it
to
doesn't give
be.
you everything, but a couple of paragraphs, if not one, would have sufficed and made the clarification there
Yeah.
as to what it was then
Well, we can make
what it was now.
suggestion to that. Yeah, we can make suggestion to that particular paragraph that it need more information or an example to be put into the paragraph so that the individual will understand. Because what I'm getting from this paragraph, if the individual did not commit a crime, a criminal activity, and he or she was deported on, that means the Home Office would have made an error.
Are you
Right,
saying
but
then, is your
And if you
understanding?
remember, well, 1 minute.
Hold on, Gary, let's stick to this point here. Are you saying if an individual was deported, not for criminal offense,
Yeah.
then on that basis, as per this, then that the deportation be a wrongful deportation?
Yes, because there were many people who were
Hold on, Gary.
deported.
I understand that. That is your point.
Yeah.
But when the reader, and let's not forget, we're not the one that said, the Home Office said, you do not need legal representation to apply to the scheme.
Yeah.
When the average person that's read that, are they going to, if that what you're saying is correct, let's assume that what you're saying is correct. When the average person is reading that and making an application, is the clarity there for that individual to understand clearly that that is the argument that
No,
is being
it's not
there?
Clearly for them, because this is the
Exactly.
problem. We're making assumption that everybody can read and that's not the case. Even advocates have difficulty with the guidance, but they
not whether
have a
you and I
little
can,
bit more knowledge, a bit more
it's not
knowledge
whether
around the law, immigration law.
it's not whether you and I can understand it. It's whether the average applicant can understand it. The same applicant that the Home Office and the Home Secretary somewhat and the Minister is saying do not need legal representation. Are these individuals, are they going to understand what we just read? What is just
I
read?
hear that.
You just read
I
there?
hear that. But then how?
No.
The next thing that we would in challenging this point in the guidance, right? We would need to then say, have a number of people or a number of cases who just, have no idea what this is all about, and that is quite difficult, a difficult argument to put forward, because what we're saying is that the guidance is not explicit enough, right? The average person will not understand this, and that is probably quite correct. But how do we balance that with people who are stuck with and haven't proceeded to an application because of this point? We haven't got that information.
We shouldn't need that information. We don't need to get to have case or case studies to establish that there is not specific and unclear. We shouldn't have to get to that point. We should be able to read it and identify as is not clear. It is not clear.
I think
I do not, hold on, Augustine. I do not go down this road that every time we meet a challenge, we have to bring forward case study. Don't need to do that. It's obvious it's not clear. If it's not clear, get an organization like the Crystal Clear English or whatever the term is that will look at that and identify it's not clear, just like the applications weren't, and they look at it and it's written in crystal clear English that the average person can understand exactly what it's saying. And this
I mean, I hear your point. I do hear your point.
Argument.
Yeah, it's a good point. I do hear that. But maybe that because if you compare the previous version, this information wasn't in the previous version. So something has happened in between that this information has now become updated into version 8. If we want to challenge what's here and say, okay, we don't think that there is enough, this is not clear enough for applicant, then we can do that. Yeah. I mean,
well, we should. We need
we can do that. I mean,
when these updates come out, when
This
these
was
updates are out,
November 24 last year.
when these updates are out, we need to check them and make sure that they're clear and whatever information is being presented is transparent and can be understood by the average applicant, but just by advocates and not just by legal practitioners.
Listen to this. The factors. This is important because
Just get Egbert. I'm sorry, Augustine was going to say something.
Yeah, one more. If I read this, Augustine, you can come in now. Let me just finish this. Factors for consideration. You must consider the following factors when assessing whether a person can be readmitted to the UK as a returning resident under the Windrush scheme. And then there are 3 bullet points. Their strength or ties to the UK, including the nature of those ties, the extent to which those ties has been maintained during the applicant's absence, the length of the original resident in the UK, the length of time the applicant has been outside the UK, the circumstance in which they left the UK, and their reason for remaining absent. For example, those within the Windrush cohort may have left the UK under the impression they were British citizens and so believe there was no restriction on the time they spend outside the UK. And 2 final points, their reason for now wishing to return to the UK, whether they were able to readmit, they would continue, whether if they were able to readmit, they would continue to live in the UK. Any other compelling or passionate factors to be considered. This is the guidance for the caseworkers. There are 9 bullet points under that section for consideration. So I don't think the individual have to fulfill all of those, but clearly those nine points there, the caseworker would be measuring against, to determine whether the individual application for re-entry is approved. Say, for example, joining family, whatever tie, you got to establish that. Because it may be that when they consider how long the individual has been away from the UK and what ties they have in the UK, they may make a decision based on that purely.
Individual may have had challenges maintaining those ties and due to the
and that does say that it does keep.
Hold on. The individuals may have had challenges maintaining those ties due to information that was given to them, incorrect information or misleading information that were given to them by the High Commission in wherever they're stuck or locked out or exiled. And in such situation, that individual should be allowed to return to the UK. If they stayed out of the UK,
it does say that. If you look up, I read the paragraph again. The circumstance in which they left the UK and their reason for remaining absent. For example, those within the Windrush cohort may have left the UK under the impression they were British citizens and so believe there was no restriction on the time they spend outside the UK. So one would have concluded.
Gary, just hold on there. That elaboration that is there, is that a part of the update?
It is. Yes.
So that was all done prior to the update. What you just, that most recent sentence that you just read, that was not in the update. That was not in the previous version 7.
No,
that was not in the where it made reference to that individual left the UK and the assumption that they're British.
Yeah.
and stayed outside the UK. Specifically now, that is not in version 7.
I know that. That was not in the version 7.
Right. So if that is not in version 7, right, that what you just read there can be very impactful if we push to get clarification and for that to be action going forward. Do you follow what I'm saying?
Yeah, I get that. Yeah. But and then it's other compelling or compassionate factors. So those other factors, again, they're not defining that, but they're saying, there may well be other compelling factors that has led to that person's situation.
I understand. So what we need to do, we need to engage the community engagement team as well as policy to get clarification on that, get specifics on that, and for that to be action going forward. So we need to be pushing on that there. I think we should allow Augustine to say what he was going to say.
Yes, please, Augustine, come in, please.
Well, by that point, I think just adding more requirements. The reason we have compensation is that people were locked out, and it's due to the Home Office. Why are they saying all this? For instance, if you were deported because they consider you a legal migrant, why is it up to that individual to go to the deportation department to get it cleared? The Home Office can easily do that. They have the records. This is all part of the Home Office. They should be clearing that right off the bat.
Yeah.
And the other thing about that point you said about was it that we were a family matter, close connection.
Yeah.
After 40, almost 50 years, we don't need to prove that fact of having close connection to the UK. They already severed that. Why is this a determining factor?
Well, I can't answer that question, but what I'm saying.
No, but you should be putting that to the Home Office. This is not necessary. This is not necessary. They caused this, and why have we got to do all this? Once it's proven that it's proven I'm Windrush, yet still they won't give me compensation because of their feelings that I have no connection, or I didn't put in enough effort to return, or I let my ILR to lapse. This is not my doing. This is their doing. Why?
Yeah, but the onus is always on us. Now, the burden of proof, the onus is on the individual making the claim, right, to evidence many things. Now, it is correct that the Home Office do have inter-government department that can find information, but the fact is the individual would have to at least, that email address that I just referred to, the individual who have a criminal record to have it revoked, they would have to email that address with their details in order for them to be identified in the system, that individual was deported at a particular date and a particular year.
I understand that, but this is all the Home Office doing. So why are we the ones have to be scrambling? And if we don't get it right, this is not.
Yeah, I know, but we can't. Right. Sorry, we can't change that because again, we have to supply the information.
Can I just comment there, Gary? I think Augustine is 100% right. Yeah, it should be done by default. Hold on. Gary, it should be done by default. they shouldn't have to, like Augustine, are the impacted, shouldn't have to go out putting out all that effort and be plowing around trying to get information to evidence that that is the situation. So it should be done by default. All this thing about having case studies and gathering information and so on, evidence and so on, we need to get away from that. Once the wrong has been identified, it needs to be reset. So just like they said earlier, prior to election, this should be part of the reset by default. When the wrong is identified, reset it by default without the impacted have to put out any effort, so to speak. All the effort should be on the wrongdoer's part. That's all on Garrick. Should be on the wrongdoer's part. In addition to that, this thing about strong and continuous ties, I think is a load of nonsense. It's prejudicial in many cases. Let me give an idea, an example. Two brothers. One came to the UK, got married, etc., had children. The other one chose not to get married, chose not to have any children. Both brothers went outside the UK, lost the indefinite leave to remain. Why should the one with children have a better chance of returning than the one without children? Doesn't make any sense. Both of them lost the indefinite leave to remain due to the fact the indefinite leave to remain lost due to the time they stayed outside the UK. They should have the opportunity to return. Just they should not do it one the one that bought the house here, etc., the business here, and so on and so forth. The other one didn't want a house here, didn't want a family. So why should he not be able to return just like the other one? It doesn't make sense again. That needs to be resolved. And in many cases, the decision is discretionary, i.e., the caseworker, the immigration officer, can make the decision whether to allow that individual in or out of the UK. He may not. He may get up one morning, the day, making the decision based on what happened, what experience he had the day before. That is how discretionary decisions are made. They need to get the discretionary option out.
Yeah. But the thing is,
hold on, Gary. The decision needs to be made based on the facts and the evidence and the circumstances as is, without any discretion. That is bordering on corruption. Back to you, please.
Yeah, I mean, the guidance as it is, now, we've always said this, right from the start, the compensation scheme that we have at the moment, there has been tweets and tweet and tweet. I mean, in some ways, some people would even say it's, it need a complete redesign. But what we have is a scheme that's been running since 2019, and there has been a number of tweets and changes, etc., since then. And if we're saying that the entire scheme need an overhaul, then it's a good point, yes. But there's also this issue as to when the guidance is updated by the Home Office, we don't know the basis for those updates, whether it has come from organization suggestion, whether it's come from civil servant. We don't know where all of these ideas has come from. However, the point you've made is a good point, yet we still have to operate in the guidance. This thing about close ties with the UK and family is re-emphasized in version 8, where a person has close family ties in the UK, which has been maintained during their absence. This will likely be an indication strong ties. So this is what the caseworker is saying. This will indicate strong ties. The more immediate family members are, for example, parents, spouse, partners, children, grandchildren, the greater the strength of those ties are likely to have. However,
He's a cute now.
relationship with
I mean, the family sharing.
wider family members, such as cousin,
Visible.
niece,
That's all.
nephew, may
don't-
also be taken into account if those ties has been closely maintained. So this is what the Home Office caseworker would be looking for, according to the guidance here.
Yeah, we understand that, Gary, we get that. We're sort of going beyond that now. We understand the scheme as is.
Your volume is going down, I can't hear you properly.
I'm saying I understand that we've got to approach the scheme as is. The scheme, there's a scheme that we've got at the moment. We understand and how we need to approach it. However, we're talking about changes to start having two discussions.
Yeah. I hear what you said.
And the necessary changes in order for the scheme to make sense.
Yeah.
Remember, the whole essence of the scheme, the spirit of the scheme was to put those impacted back in the position they would have been had they not been wrong. As is at the moment, is not putting those wronged back in the position they would have been had they not been wrong.
Yeah.
Yes,
but it may be then, and this is a good point, it may be, don't forget, the 30 recommendation that Wendy Williams had put forward that was never implemented, those are still outstanding. And if those 30 recommendations are implemented, would that not resolve some of this?
It will resolve some of it, but it will go nowhere resolving all what need to be issues. A lot of the things, recommendations that are put forward by Wendy Williams does not actually, is not aimed at those impacted. It goes beyond Windrush. Right, so we specifically about Windrush. It goes into other things, other areas. It goes to wider immigration areas, are issues. Okay, it goes beyond that. So, in terms of redesigning the scheme, or making changes to the scheme, as far as I'm concerned, that is a semantics, because what needs to happen is for us to look at the scheme as is, the one that we've got at the moment, understand it in its entirety, and then from there, we look at the scheme or have some idea as to what the scheme should be. Then they look at the scheme that we've got, adjust and make changes and scale up accordingly. So whether it's a redesign, I don't think you need to tear the scheme down and start again. You don't need to do that. Identify what you've got and know clearly what you would like, and make the necessary change to what you've got in order to, for what you've got, mirror what you need to have. It's not, we're not talking quantum mechanics here. It's as simple and straightforward as that. I'm not going to get into the semantics of starting again, redesigning or adjusting. Doesn't matter which approach or what terminology is used. What is important is end result to get what we need at the end of the day. The quickest and the shortest way with route. We don't need a long drawn out protracted process to get to there. Once we're clear and concise as to what we've got and what we need. If we have not got a clear understanding of what we've got, then it's very unlikely that we'll get to where we need to be and what we need to have.
Yeah.
This thing about the scheme is not working, it's not fit for purpose. We're long past that stage now. What we need to be saying, in addition to that, is why it's not working and what would work. That's where I'm at.
Yeah, I hear that. And so some of that improvement that we would like to, to the scheme, isn't that included in the ARE manifesto that we identify those gaps that we want improvement to?
Some of it is identified. There are suggestions coming from all over the place. All these ideas and suggestions need to be brought into one space, right? And then have the discussion, and that process, that's in process already, that's in motion already. And then hopefully the Windrush Commissioner will have the remit and will have the teeth to implement the right mindset, the right skill set and intention to implement accordingly. That's what we need.
Yeah, I hear that. And the thing is, the current updated version of 8.0, as we've just been saying, there are a number of things that we think can improve in the 8.0. If we can identify out of that what changes we want to improve, then that may be something specific that we can push for the commissioner to address.
And the next engagement with the community engagement we have with the engagement team, we will forewarn them and ask them to be prepared, or someone that can come and tell us clearly
we're going to need
the difference.
the policy and the
whosoever it
caseworker.
is, whosoever it is, right? It's for them, for the community engagement team to identify the relevant individuals with the appropriate understanding. For that individuals to come and explain clearly the difference between what the changes are that were made on the 1st of November last year, and the difference between version 7 or whatever it is and version 8, and the implication of those changes, how they will impact. So we need to send them an email and let them know when the next engagement is, whenever that is, and for them to explain clearly in public what that means, not in legalese, in clear, straightforward English, crystal clear English that we can understand. Just hold on a bit, Gary. Peter, I see you keep unmuting. If you need to ask a question, just raise your hand, and we will allow you to. Would you like to raise a question, Peter? Just give me a nod your head. Is that a yes? Peter, can you hear me? Unmute, Peter. You're speaking, but I can't hear you. Would you like to ask a question?
Okay. I don't even know where to start from. But my dad been here like in the early 60s. He came here before I was born, and I was born August 16, 62. So he came here in 62, early 62, before I was born. And
Just a quick question. Just hold on, Peter. Sorry for interrupting you. Where were you born?
I was born in Jamaica.
Right. Have I spoken to you before?
I'm not sure who I'm speaking with, but I think
you're speaking Roland.
I think I spoke to you over the weekend,
right,
and you told me that.
On that basis, I will speak with you off the Zoom. I'll make contact with you tomorrow.
Okay.
Okay.
Okay, not a problem.
Okay.
Just going back.
Back to you, Gary.
Yeah. Just going back to, as I said, I think all of us need to get familiar with the version 8 of the guidance that the caseworkers are using. Now, clearly, in the version 7 previously, I don't know those nil award, and I don't know how many nil award has been made. I do know that out of Sheffield, a lot of nil award is coming out of Sheffield. Now that we've got version 8, which came out November 24, we need to be sort of focusing on, the new guidance and see how that new guidance is impacting on individual. Now, we've always said that before an individual submit an application, we always say it's good to make some drafts using the guidance before you do a couple of drafts, but also get somebody to look over it if you can, or even better still, get an advocate to help you with your application. The reason why we say that, because sometimes when an individual is writing things down from their own memory. They don't always remember certain things. Having a third party or somebody separate will prompt you and ask you questions relating to some of those points in the guidance, whether or not it relates to employment, whether it relates to housing, whether it relates to trauma, whether it relates to, losing your job, your house. Somebody will prompt you in order to get you thinking about, what has happened to you. And don't forget, a lot of these cases is where an individual have experienced things for many years. It's not a sudden thing. It may have happened in the 60s. It may have happened in the 70s. It may have happened in the 80s. Yeah. And trying to recall, your experience then, it's not always easy on your own. But when you get the assistance, somebody will be able to trigger your mind and say, oh, well, what happened then? Where were you working then? What happened this? And that will help you to sort of get a good history of your case, because an application is your life story. It's basically what has happened to the individual.
I think you might have a little disagreement.
Sorry, somebody who was just speaking there. Okay, so access to advocacy is important. Access to somebody to help you with your application is important. I would rather see people reach out for help than send an application in that is incomplete and does not really cover and address your own issues. Yeah, because all that will come back is that it'll come back is a nil award, because it hasn't been populated sufficiently. So it's always best to get help. But there's also the other thing. What we found, that applicants who use a legal person, a solicitor, they never get a nil award. They never get a nil award, because the lawyers, they know how to apply the immigration laws and the claim. And so the issue must be then with individual trying to do the application themselves. Roland?
Earlier when you asked about time scale and how quickly the claims are completed.
Yeah.
Obviously that has been an issue over the years.
Mm.
That has never been my main concern, even though it's an issue. My main concern is the amount of the award. That's the big issue. Awards are too small, needs to be raised. I've been submitting a number of claims over the past months. I've had preliminary offers within 42 days. I've had about mainly primary claim and close family member claims. I have had completion of primary claim, final decision within 4 months.
Mm-hmm.
I've had completion, final award of close family member claims within 12 or 13 weeks. I've had preliminary award within 42 days for both, within 6 weeks for both primary claim and close family member claim. They have speeded up the processing quite a bit, especially when you present all the evidence up front. I'm talking the basic information. So in terms of a close family member claim, the primary claimant has already, our deceased estate has already been awarded. And you're submitting the close family member claim. You've got the application completed, all the relevant information. You've got the ID, proof of address, and you've established from the get-go the relationship between how the primary claimant or the deceased individual and that close family member is related to the close family member that's making the claim. Once you get those in,
Yeah.
From my experience, things are going through really quickly. In a number of cases, about within 5 weeks or so, 6 weeks, they'll write you and ask you, have you got any further information? Get that information to them pronto. It doesn't take long. Sometimes you can even submit that additional information on the phone. And then quite a number of instances that within a couple of weeks of you, they're asking you for the final additional information, you submitting that, telling them that there's no additional information, then you'll get a decision. Once the decision is made or the award is made, and you complete the application of the bank details, etc., the claim response form, and return it to them within a couple of weeks, if not less in many cases, you will get the award
So what you're saying, it's the amount, it's the offer. So, you know, the time is not the timeline is not the factor.
The timeline
it's
as
the
to how long it
offer.
take into
It's the offer.
how long it taking to complete the claim is not the main issue.
Yeah, I hear that.
The main issue is the award, the level of award.
Yeah, and I know it is the case.
Cutting it.
It is a case where you get the first offer. Some people may accept it, some may not. Some, you know, again, evidence shows that, you know, the lawyers, the solicitors, and the advocates, you know, get a better offer than an individual submitting the claim. That is evident, and you know, it may be because of experience, etc. But
another issue that is quite an issue, especially for close family members. For close family members, really, is in many cases, father's name are not on the birth certificate. That has been an issue. Got a few cases I'm putting through at the moment where the individual's father, children, father, name is not on the birth certificate, and we're exploring the option of DNA. They have not gone definitive, and it's a number of caseworkers have said they think they will accept DNA, and we have submitted a number of cases on that basis, and we're hoping within the next few weeks, decisions will be made and DNA being submitted to establish paternity.
And that's a very good point, because we do know that many fathers, you know, the mother will register the child, and you know, go ahead and register the child without the father details, etc. And so yes, you'll have a birth certificate that only have the mother's information. Because in this country, I think it's the same elsewhere, you have what they call a full birth certificate. The full birth certificate will have mother and father information and occupation, etc. And the little small one, the little tiny one that we get, will only have the mother registering the birth. It would not have the full details. Yeah. And you know, the full detail is really important, because if you have the full detail, you don't need to go down the DNA route to establish, you know, lineage, etc. Now, it's about 8 minutes left. Can I just ask, is there any particular question that we want any clarification on what we've said so far? We're encouraging people to use the 8.0 guidance that came out November 24. That's the updated version. And also, please check you're using the latest application. Yeah, it's good to make that check. You're using the latest version, application and guidance. And you can find all of this on the .gov.uk/Windrush compensation scheme. As you do that, you will get the latest version up at the top of your search. It will tell you the date, 1st of November 2024. Make sure that is the correct one. We've always said the caseworker's guidance. It's a lot of reading. It's over 100 pages, but it's a good reference point to check your question and the relevant section that you need to answer. We're not suggesting you read the entire full caseworker's guidance from start to finish, but you have the reference and the content. And here we have, for example, let me just tell you what it says about this guidance. You have the background, you have Commonwealth citizen, its meaning, you have operation of the Windrush scheme, deciding the Windrush application, you have a section deportation, you have a section on Windrush scheme group, you have a section returning resident, you have a section on close family ties, you have a section on employment. You can find everything you want in that casework guidance. You just need to check against what you need to answer. Yeah. So if you're going to check your employment, you just look at that section to do with employment. If it's something to do with housing, you look at that section about housing. If it's something to do with trauma and mental health, you look at that section. It will help you to formulate your answer on the application form. And we always say, do not start writing anything on the application until you consult the guidance. Read it over and over again, okay? So that you're familiar what is being asked of you.
Can I make a number of announcements, Gary?
Go ahead, please.
We've got a number of events coming up for the summer to promote the Windrush scheme, as well as campaign events to get changes to the scheme. On the 12th of April at the Black Workers Conference, TUC Black Workers Conference in London, will be hosting a Windrush fringe meeting, I think from 12 noon to 1 p.m. And this will be primarily about discussion, will be about the Windrush Commissioner's remit, the aim, purpose, and how they can influence any changes. We've got a number of events that we'll be hosting in London as well. And also got a number of events coming up in Jamaica. First one being on Saturday the 19th of April in St. Thomas, and we've got others coming up. And there will be an event in Jamaica on the 22nd of June, Windrush Day. And we've got one also lined up one lined up in the USA, working on one for Fort Lauderdale Windrush International Forum, because there's quite a number of individuals and the states in the United States who have been impacted by the hostile environment. And one in Fort Lauderdale, we will be encouraging those individuals who have worked in the UK for some time and have lost contact with the UK. Those individuals in the USA, in some cases, will be entitled to get some pension from the UK state pension, not a full pension, but some pension from the UK state pension, for the mere fact that they have worked in the UK for a number of years. In some cases, even if they have only worked in the UK for 1 year, it may be possible for them to get some pension from the UK. So keep watching the space. We'll keep putting the information out there. Quite a number of events coming up that will be hosted by Justice for Windrush Generation, along with others in combination with other organizations, individuals. Back to you, Gary.
Yeah. And in addition to what Roland just mentioned, the 6th of April in Brixton, Windrush Square, is the annual vigil. And it will be 7 years since the scandal broke in 2018. And the annual vigil will take place on the 6th of April. It will always be the 6th of April, regardless of the day. It will always be the 6th of April. This year it falls on a Sunday. from 12 till 2. And after 2, inside the National Black Archives, there will be the Home Office team inside where people can get information directly from them. You would probably have seen some information from Windrush National Organization promoting the vigil. So it is an annual event. It's a free event. The Minister Seamer will be present at that event on the 6th of April. And there will be other guest speakers from different organizations present at that event on the 6th of April from 12 till 2. And then for other information, 2 till 4, there is a Home Office team present. Just to say that all the events that just been mentioned is promoted on the Eventbrite platform. You can always find out what's happening on Eventbrite. We haven't confirmed the next rally. It's May, waiting for the MP to give us a date. So that will be the next rally for May. Some of the points that's been raised about the guidance can also be mentioned and discussed when MPs present. We always, at the end of our session, ask the MP to take up 2 or 3 points out of the rally for the Home Secretary and the government directly to get answers. That's been the format since January. We're continuing the theme. As it will be the same theme every time for the rest of the year, about Windrush, what next? Fundamental reset. When will we see the evidence of the reset? And of course, when the new commissioner is appointed, how effective that new commissioner will be in bringing about those changes. It would appear that that's the vehicle to bring changes is the new appointment of the commissioner. So the commissioner will be able to meet with organization and stakeholders to drive improvement into the scheme and bring about changes. We will continue to challenge the government on the promise that they've made on a Windrush reset and bring about fundamental change. And that's important because that is what they've said publicly. And we're yet to see those things, tangible evidence. But yes, we will continue to push that agenda. And we also want people to come forward and make application, because it's no point we pushing the agenda to keep Windrush and bring about changes if people are not coming forward. We still need people to put application in, whether that would be primary claimants for themselves, whether that would be close family member claim, whether that would be a deceased claim that family is now having to do because the primary claimant had passed away, and now the family have to represent them. We need those claims. People need to put those claims. It's no point we're doing the campaign and people are not coming forward to put claims in. Whether they're in the UK or they're outside the UK, we want people to come forward and put claims in. Okay? Because we don't know how long the Windrush compensation scheme is going to be around. The commissioner appointment is for 3 years, so we don't know whether at the end of 3 years, what will happen. So we need to be focusing now. Let's get people applying to Windrush scheme. Just tell people where to go, where to get help. Go to the website, justiceforwindrushgenerations.co.uk. There you will find explanation of who is eligible for the scheme. It will explain about primary claimant, close family claim, and deceased claim. It will also have links to other organizations that we're working with, so that if you need legal advice, there's links there. But do share the information with friends and family, because we want more claims to go through the system. Yeah. Don't forget, the majority of claims has been for European. Just under 5,000 claims was submitted by European after Brexit to rectify their status after Brexit, right? We don't see 5,000 applicants from Jamaica. We don't see 4,000 applicants from Jamaica. So we need people to come forward, and everybody is listed on the Home Office site. The 65 country is listed, and you then get a breakdown of each country, how many people apply to this scheme so far. There you will see numbers, and those numbers doesn't reflect the global situation. Yeah? So people need to come forward and make application. Yeah? Doesn't matter where they are in the world. If they're eligible, they need to come forward and make application. Yeah. So thank you very much for this afternoon. I hope the information has been useful. As we said, we focus solely on the Windrush compensation scheme and status. We don't discuss any other thing because we want people to benefit from the Sunday chat of understanding the Windrush schemes and answering their question and signpost them how to get further help. Yeah. So is there any final comments that anyone would like to make before we finish? I know it's summertime begins today, clock went forward. Any final points? Okay, so just to remind you, it's the second and last Sunday of each month. Second and last Sunday of each month on this platform, Windrush Sunday Chat. Great, thank you very much. And we look forward to see you on the next session on the second Sunday in April.